Hey, what's up guys? Aaron Bennett here. Let's talk about Celsius updates. What's happened since my last video? Well, I'm going to touch on this update from the UCC. And in this update, they talk about two things, the substantive consolidation and also the fraudulent transfers. These are two things that were talked about in separate motions that came through the docket. So I'm also going to talk about this appeal from the Series B holders because that is what Series B does. They basically don't want anything that gives creditors or customers more money because they want it for themselves. And then finally taking a look at the next big date, which is going to be July 24th, going over the plan, so what's been going on with the auction, and also anything else having to do with loans earned in custody, just kind of bringing you up to speed. So White & Case, the law firm representing the UCC, talked all about this fraudulent transfer. Now, they go through this entire document. I'll cover a little bit about what happened here and what they are fighting for, and then talking about substantive consolidation. So two different motions that came through the docket. I will go over both, and that is what they said in their latest update and why they are fighting for these two things. So as always, if you have not subscribed and you are a Celsius creditor, hit that subscribe button. There's also going to be timestamps below if you just want to skip to a certain part. So first, I'm going to go over the UCC's fraudulent transfer complaint. They say that Celsius Network Limited, this is the original UK company, entered into a series of sham transactions designed to keep its business running at the expense of its customers, who as a result may find themselves with no recourse against the entity that actually holds a material portion of the digital assets. They basically said that this LLC was all a facade, and in fact, Celsius Network Limited, so the original UK company, retained nearly all of the customers' assets. But at the same time, Celsius Network Limited, the UK company, transferred billions of dollars worth of liabilities to the new LLC company based in the United States. So the original company kept the assets, but transferred billions of dollars worth of liabilities to the new company. So they are setting the stage for this fraudulent transfer between the two. They go on to say that the Celsius Network Limited entity also caused the LLC to transfer assets that it subsequently received from customers to Celsius Network Limited and away from the LLC, further deepening the LLC's insolvency. So any assets that were transferred to the new LLC company in the United States were then transferred to the limited company in the UK, making the LLC just have less and less assets. And the UCC holds no punches here, saying no matter how you slice it, Celsius Network Limited used the LLC for its own purposes, fraudulently transferring billions of dollars of assets. So what happened is the limited company transferred the customer liabilities to the new LLC company in the United States, and then the LLC apparently loaned customer assets back to Celsius Network Limited, and the thousands of intercompany transfers in which the LLC sent crypto to Celsius Network Limited to meet the criteria for constructive fraudulent transfers. Now, why are they making this argument? I'll get to it in a moment, but really it is an argument that needs to be won for us, the creditors, in order to get as much money as possible. So here's what they say. Celsius Network stakeholders, so again, this is the UK company. The stakeholders in that company, which include equity holders who had board seats at Celsius, should not be permitted to benefit from the complex web of transactions that Celsius Network Limited spun to evade regulatory action meant to protect its customers. Wow. And conceal its fraudulent receipt and retention of billions of dollars worth of customers' assets. So what they're saying is these stakeholders and board members should not profit from basically sham and scam and fraudulent transfers. And here is where they sum it up. They say, accordingly, the court or the judge should allow the LLC, this is the company in the United States, to avoid and receive a claim in the amount of the liabilities fraudulently transferred from CNL to LLC. And here is a picture just going over what I was just talking about. So we have Celsius Network Limited right here. This is the UK company. Then we have the LLC, which is based in Delaware. Now, the whole thing going on with the UCC filing a class claim for us, again, just to remind you guys, that was because the court and the judge recently said back in February is that we, the customers, do not have contract claims against any entity other than the LLC right here. So what the UCC is arguing for in this first motion is the fact that the UK company did all of this fraudulent, scammy, possibly illegal things, and the assets in the UK company, the limited company, should go to the customers, should go to you, should go to people that were basically deceived and defrauded, people that have claims over the LLC company. So that's their big argument for fraudulent transfers, and this is the UCC's other argument for substantive consolidation. So they start out by saying that C&L, Celsius Network Limited, and the LLC are and always have been functionally the same entity. And again, right here, the limited company and the LLC, they're saying have always been functionally the same entity. They talk about this migration from Celsius Network Limited to the LLC, which again is right here to right here. That was a sham, they say. Why the limited company transferred billions of dollars worth of liabilities to the LLC. Like I said before, Celsius Network Limited retained nearly all of the assets associated with those obligations, which it then used to deploy in supposedly money-making investments, despite warnings from the FCA, a UK regulatory authority that C&L over in the UK was to cease all retail operations in the UK. So essentially, this original C&L, Celsius Network Limited, was told by the FCA to stop everything you're doing, cease all retail operations. But instead of doing so, there was a sham of a migration, essentially transferring all of the liabilities to the LLC, and Celsius Network Limited in the UK kept all of the assets. They say that Celsius engaged in a series of transactions that purported to separate Celsius's assets from its liabilities and left the LLC, in the words of this court, quote, hopelessly insolvent. So more about this substantive consolidation, basically combining both of these entities. They say, and they mention again, that the documentation of these agreements of this migration was shoddy at best and non-existent at worst. So we've known this for many, many months, but the record keeping, the documentation either does not exist or is so bad that it can't even be relied upon as fact. And they are just saying that, again, this migration doesn't even have the proper documentation to support what happened. So this is a long document, but essentially substantive consolidation is warranted under governing law, they say. So not going to go through it all. There's a lot of details, which is very, very good to read, but I don't want to make this video incredibly long. So let me go to what the UCC said, because they talk about both of these things. They say that last night, so this is going to be like 2 nights ago, the UCC and Celsius. So when they say Celsius, they're talking about Kirkland and Ellis, the law firm representing Celsius. So both the UCC and Celsius took decisive action to protect account holders in matters involving Celsius Network Limited, which holds the mining assets and is where the preferred equity holders invested. And that is why the equity holders, or also called the Series B preferred holders, they are appealing all sorts of things. So in this latest appeal, they are appealing for the UCC to file a class claim. Now, my understanding is that they are doing this because if the UCC filed a class claim, they, the equity holders, would not get as much money back. There would be less of a chance for them to regain some value from their equity investment. So back to the tweet from the UCC, they say first the UCC and Celsius filed proceedings to substantively consolidate Celsius Network Limited and the LLC. So again, we have the limited company and the LLC. This would let the account holder creditors of Celsius Network LLC, so that is going to be you. You are an account holder creditor of the LLC. This would allow you to get treated as a creditor of the limited company and receive that entity's value. So the limited company has, I believe, over $1 billion of crypto. They have the mining and also the proceeds of GK8 and other illiquid investments. Second, the UCC, on behalf of the estates, filed a lawsuit against Celsius Network Limited to unwind fraudulent transfers that dumped $10.3 billion in liabilities onto Celsius Network LLC. So again, going right here, we had the limited company dump over $10 billion of liabilities into the LLC, but they retained all of the assets. And the UCC said that the limited company pilfered, I don't know that word, but pilfered billions of dollars from that entity. And finally, they say these are steps that are designed to provide value to account holders no matter what the outcome of the auction is. So that is true. We have all of these things happening at the same time, which is quite confusing. And before I get into that, right here, the auction actually was happening today, and I believe it's going to continue. So the auction has been going on for like, I don't know, 6 days now or something, which is kind of a long time, but I take that as a good thing. And this date right here, July 24th. So this is going to be when the evidentiary hearing regarding this whole idea of substantively consolidating the entities will be held. So July 24th, right now, I'm recording this sometime in like, I don't know, early May. We have 2.5 months before we really have an idea of whether the LLC and the limited company will be treated as one entity. So if you're like, why does this matter? Why do I care? Well, for one, it means that I don't see a bid being approved and everything getting approved regarding a plan before July 24th. So we do have some more time. This is not news for anybody that's been following this for a while, but July 24th is going to be an important date. Hopefully we get some clarity on this, because ultimately whatever plan gets approved assumes that these entities are going to be consolidated. For example, the plan with novawulf assumed that mining would be a part of that plan. So we need to know, are we going to be getting access? Are the creditors going to be getting access to all the value at the limited company? So we will have to know what happens in July for this, consolidating both of the entities and also this $10 billion plus fraudulent transfer. This will have to be settled before we can really clearly move forward with a path, whether that's a Chapter 11 liquidation, which basically just like unwinds everything, or we have one of the bidders come in and do a whole reorganization plan. We really need to know the outcome of these issues. So that is basically it for now. Just to recap everything, we are waiting on this auction to see what happens with this. Hopefully we get a better deal than with novawulf, but novawulf may be the one that wins. We have no idea. I have no idea. I didn't sign the NDA. I'm not listening to this auction, but from what I've heard, it's a lot of not talking. So I don't really know what's going on there other than the lawyers billing the estate a lot of money. I did hear that people who have custody assets who signed the settlement agreement will most likely get that first chunk of money in the next 1 to 2 weeks, which is very good. And I know that the loan ad hoc group, so if you have a loan or if you got liquidated, I'm hoping they include you guys as well. The loans are coming and will be coming to some sort of resolution and agreement. Maybe it'll be something like a settlement there as well, but I know there's a lot of movement happening with the loans too. But for those of us who are in the earn camp, basically earning yield every week, we are still waiting on the outcome of the auction, the outcome of what's going to happen with the assets. Are we going to get a smaller distribution up front? Are we going to get more down the road? And honestly, this may go until the end of the year. So we don't know how soon we'll get a liquid distribution if you're an earn, but don't expect anything until, honestly, end of the year, maybe beginning of next year. Things are taking a little longer than I thought they would, but things are moving in the right direction now, which is very good. And regarding the UCC's class claim, well, the Series B just appealed it, so there will be some back and forth. This has not been completely signed off by the judge yet. So right now, again, there's no bar date, meaning there's no date that you have to submit a claim if you want to. So there's no rush to do anything right now. So whatever camp you're in, there's nothing you need to do other than subscribing to the station and paying attention to my videos, because when there is something that you may need to do, I will definitely let you know. All right, guys, hope that was helpful. Till next time, talk with you soon, and bye for now.